to consider with respect to the forthcoming amendments to the Senate rules, but I hope that answers the question of the honorable gentleman, Mr. Simply BTZ. Is there a second?
I object, and Mr. President.
Very well. Actually, since you're not seconding, the motion fails.
Mr. President.
The leader of the Senate.
Mr. Chen has approached me menacingly, and I'm not comfortable with that. However, I will match the vibe of Mr. BTZ and the member for Palmer North, and move
Thank
that
you
we
for not
exit.
naming a member in the chamber.
I'm trying. I'm doing my best. Move that we exit legislative business and move into a question period. With Mr. Chen.
Is there a second? Who's doing it? Send me photos. Respond, Arthur.
He's just sitting there screaming. Simply, do you want to take over streaming? I don't want to stream anymore. There you
go. The motion is heard and seconded without objection.
Hello.
I'm gonna wait until you come to the chamber before we begin. I don't want to do more voice call statements. If you could hurry your way here, that would be appreciated by the chair.
Not too fast, though. I'm going to step away for like 2 minutes.
I'm coming.
I am very tired. I would apologize to members for my apparent grumpiness. I'm quite sleepy as of this time.
I can take over for you if you need me to, Large.
You absolutely will not.
Just thought I'd offer.
Your offer is heard and rejected. Thank you. That is the order of the court. Thank you.
I'm almost there. I'm ETA 20.
Superior Court for the State of Ridgeway by and for and within and outside and inside and on the top of and the bottom of Ridgeway County. By the way, I do think it's pretty funny that you read people their rights and stuff, and you say it as quickly as possible, slurring your words basically. And you said, "Yes, sure, you," and then the witness goes, "Oh no, what part does he understand?"
Yep.
Is he here?
I'm right here.
Did you
Hello.
make it?
I'm
Hello.
right here. Hello.
Hello.
Ordered. Statement, Mr. Arthur Chen.
Hello, colleagues, members of the Senate. Hello again,
Colleagues.
fellow members of the government and the deep state. Hello. I am coming before the Senate today because I am just frankly bewildered. I am shocked and I am deeply frustrated. I have no idea why I was fired. I wasn't given a hint, a warning, an explanation, a conversation, nothing. At 2 in the morning today, still today? Yes, it's still today. On April 7th, there was an announcement made by Robin 5D saying that the office of Associate Director, which I had formerly occupied, was declared vacant. And I am curious as to why that is. Because I worked tirelessly as Associate Director. I graded every single exam. I completed every single piece of paperwork. I processed every single transfer, and I filed every single disciplinary document and petition for discipline in the Supreme Court. Every task, every responsibility, every detail was I meticulously, diligently, and consistently completed at the request of our state Supreme Court. And yet, despite all of this, I was fired without notice, without discussion, without explanation. And the person responsible, Director Robin 5D, is completely inactive. He is unresponsive. He is silent. He didn't speak to me beforehand. He didn't respond to me afterward. Not a single word. It was an announcement, a unilateral, unthinking decision, and now the state bar and the legal community is left in the aftermath. There are 8 members of the public who have taken the bar exam and who I graded and who I sent the release to Robin 5D's approval, but he has not sent those names to the Supreme Court. What does this say about our system? What does this say about the state bar and our legal community as a whole? What does this say about our institutions? The state bar of the state of Ridgeway is broken. It is meant to protect the professionals and is meant to ensure the sanctity of our legal community. And I am not just making this speech and this statement before the Senate for myself. I am making it for every single member of the public who is now being disserviced by a bar that no longer works for them. And I will not be silent, and I will not be allowed to have this arbitrary and ill thought out decision be swept under the rug like so many have tried to do before. Both myself and former Associate Director Toby Rules, who similarly, and I didn't actually know this until he reached out to me today, was also fired without notice after doing all of the work by the same director. And we have written a letter to the Supreme Court expressing our concerns that I will be giving a copy to the Senate of momentarily. But there's so much going on right now, and the fact that I have spent my time trying to train attorneys, recruit them into the state, talking to other communities, bringing in connections in order to have people practicing here in Ridgeway, and instead I was fired in the middle of the night for no reason or explanation. I still haven't been given an answer now. It's just beyond bewildering. So, anyways, I welcome the Senate's questions, and that's all I had to say for my initial statement.
Order. Questions to Mr. Arthur Chen, and I'm grateful to the honorable gentleman member for Palmer North. Unless the leader is yielding, he goes first.
The member
Doesn't
can go
appear
first.
to be. Very well, Mr. Simply. Chief Judge.
It's absolutely not acceptable, Senator, and this is one of the main concerns that former Associate Director Toby and I are making to the Supreme Court, because it's a failure of our public service and it's a failure of our legal system if we cannot have the director of the agency respond to people who are seeking their help.
the honorable gentleman, the member for Palmer North, has a further question, he can ask it. Otherwise, the leader of the Senate. No. Yes. Leader of the Senate.
Um. No, actually, I have nothing. No, never mind.
I've got
Thank you.
more to say too. If you want me to keep going, I have a little bit of an inkling and a counter argument too that I will make briefly, Mr. President, if still permitted.
Ordered. Are there further questions? Hearing, Mr. What's that? Mr. Sipley? That's not a thing you do. That's not an order. That's out of order.
Good effort. Good effort.
That's good effort, though. I appreciate that. And what I would say in response to the honorable gentleman is not to jump all over him as he may have felt in the past that I've been doing. I definitely don't intend to do that, and I would hope that the honorable gentleman is not hurt by my saying what I'm saying. I'm simply saying that my general practice in this chamber is not to issue particular amounts of time as previous presiding officers have done. What was done for many years in the past in this chamber is that the president of the Senate would state that a member is recognized for 5 minutes, and at which point you could yield your time or whatever. But I don't tend to do things that way. I tend to just call someone to talk, and if I get tired of them talking, I interrupt them. That's generally how I do things. What I would say to Mr. Arthur Chen is that closing statements with respect to closing statements are generally not something that I allow. If the chief judge will keep it brief, and I'll come to the leader of the Senate just very briefly. If I may allow it, but first I'm going to take a point of order from the leader of the Senate.
My point of order was with respect to the siren, an impending nuclear bomb, which is now arrived. So I withdraw.
I'm grateful to the honorable gentleman for his point of order, but unfortunately, even if he hadn't withdrawn, it's truly not a matter for the chair. Thank you. It's not. I'm not sure what to say to the honorable gentleman, except for the fact that there's not a whole lot I could do about that. Mr. Chen, as I said, if you will keep it, if the chief judge will keep it brief, I will allow him to make a further statement. But he is aware, as I warned him last night, that I can and I will interrupt him if I think he's gone on for too long. The chief judge.
Absolutely, thank you, and thank you for allowing me to speak once again. Oops, I didn't mean to hit that. I would just like to note one thing, and that as State Bar Director or State Bar Associate Director and as Chief Judge, I have been trying to recruit attorneys into our state. Okay, and that means that I have directed many people to take the bar exam. I have passed many people. The vast majority of people who took the bar exam, I let through. And I'm not doing that to just flood the legal system with incompetent attorneys. In fact, I believe that because this is roadblocks and we are not real life courts, if you're going to sit down and take the time, United stuff, if you're going to sit down and take the time to do a 6-page exam where you're willing to research and go through the process and write the responses, as long as it's not blatantly wrong, I think you should get a chance, because we have a wonderful chief public defender in her office who does probationary programs. We've got a Department of Justice who has a very good mentorship program as well. We try to funnel the new attorneys into one of those offices. So as past state bar directors, including one who's sitting in this chamber, have been very strict on the grading and the scores. And if you don't get an 8%, then you're failing. And if you use AI, then you're barred for 6 months. I don't follow that philosophy, because I believe everybody should get a shot. And if it's really bad, then, well, my thought was I would just file a petition for disciplinary or remedial action and get their law license yanked. But that was something that I have. It's a different philosophy, sure. I don't know if people agree with it or disagree with it, but that was what I felt would be best for the health and stability of the legal community as a whole. I don't know if Judge Robin or as Director Robin rather took that into consideration. I don't even know why I was fired, as I was said earlier. None of my messages have been responded to. He never told me anything before this, so still not sure. Open question, but I just would like to make the Senate aware of my philosophy, at least, and the ways that I believe the bar should be run in order to contribute best to the safety and health of our legal community for the many months and hopefully years to come in the future. Thank you.
Leader of the Senate.
Thank you, Mr. President. Mr. Chief Judge, Mr. Chen. Will you elaborate a little bit on your testimony you just gave with respect to the use of artificial intelligence, especially specifically generative artificial intelligence on the exam? You said that you do not penalize applicants for using AI. Is that correct?
The Chief Judge.
It's a case by case basis, Senator. If somebody is using artificial intelligence to make up fake cases and to give blatantly wrong answers, and that it's just 100% wrong and they're just lazy and cheating, that's obviously a problem. But if somebody is like using it to reword something or like it's their own idea, I mean, I spent enough time in state court for the last year in my state where these attorneys are using our AI all the time. That's just what's happening. So I just can't feel myself to penalize somebody just for the sake of using it if they're not using it to blatant the answers that it's giving are blatantly wrong. In real life and in here, practicing law is always an open book test, and I feel like if they can still provide the right answers or find the right answers in some way, then what more can I really say or do about it?
Leader of the Senate.
I have to express my extreme frustration and discontent with that policy, specifically with respect to the fact that when new attorneys use artificial intelligence, they never learn what the law is. Then they don't understand the law. They can't make coherent arguments about the law when push comes to shove. Frankly, Mr. Chief Judge, you're by letting those attorneys into practice, you're killing any prospect of duty court continuing well in the future. There will be no competent attorneys to be able to make actual arguments based on the law that they know in their head, because all they've been doing is feeding it into AI and making it harder for other attorneys to respond to AI slop. You have anything to say about this?
The Chief Judge. Excuse me. The Chief Judge.
Thank you, Senator, for the question. I do understand your frustration, your point, but the idea is that they are being given the opportunity to learn from not only the Department of Justice, but also the Public Defender's Office or some private practice. And it's not the fact that they will never learn. I just feel that if they can show minimum competency, that they at least understand the basic concepts, they will be able to be mentored and coached by our senior members of the legal community, myself, yourself, Madam Violet, Mr. Powell, etc., to understand and to make them better attorneys. I just don't think it's fair to hold them to standards that I know are not being met in real life. So that's why I have decided to do that. But don't get me wrong, if someone is just blatantly relying on it, they clearly don't understand it, they're citing fake cases, whatever, I still fail them and bar them from admission in the future. But I'm talking about minimum competency exhibited.
Point of order, Mr. Simply. Point of order. Point of order, Mr. Simply BTZ.
I don't think
Ordered. Ordered. I'm grateful to the honorable gentleman for his point of order. What I would say to him is that what he raised is manifestly a point of debate, not a point of order. And I think that it will be readily available for members to see the recordings
neck.
of our previous session to observe for themselves what indeed the honorable gentleman is referring to. But as the honorable gentleman has made his own point in his own way, it requires no response from me. And I will say that I don't dissent. I will say further to that, I do not dissent from the point raised by the honorable gentleman. The leader of the Senate has been making lots of noise. If he wishes to speak, he may do so.
No, I'm okay.
Are you okay there, Walter? You all right, buddy?
Excuse me. I have to say, if I can say, and whether or not I'm going to say, I will say to the honorable gentleman, the member for Palmer North, that he's growing into he's becoming quite the parliamentarian, and I thoroughly enjoy having the honorable gentleman on the floor of this house, and
Oh my god.
I very much am enjoying working with him. If he has a question, is it a point of order or another question, Mr. Simply? Mr. Simply. The Chief Judge.
I'm not sure what directives you're referring to, and I don't believe so. So I'm honestly not sure.
Mr. Simply. The Chief Judge.
Never a directive that was given to me. It was encouraged by the state bar director, and I stated that it would be redundant to publish in government announcements the results and then have the Supreme Court post their results again. So my philosophy and belief was that we would post it one time, and that was when they were formally admitted to admission by the Supreme Court, and that we wouldn't, clog up government announcements with multiple bar admissions every single week. But I don't believe that was ever an order that was given. I believe I was encouraged to do so, but I don't think that was something that, at least, it was never clear to me that was expected.
Leader of the Senate.
Just to be clear, you didn't want to clog up the announcements channel with bar admissions once or twice a week, but we instead chose to clog the announcements channel with dozens of trespass notices. Am I tracking that?
The Chief Judge.
Well, if you look back at the admissions, it was every day at one point. I was trying to recruit as many attorneys as I possibly could, and there was a week or so where we had bar admissions every single day. So it was not once a week thing. And the trespass notices, I had nothing to do with setting up that bot. I gave, through an administrative order, the power to RCSO to trespass individuals from the Superior Courthouse, but I did not have anything to do with having those notices posted in government updates or anything like that. So I'm not sure what you're trying to imply or argue here, but that's nothing that has to do with me.
Mr. Simply. The Chief Judge.
I was informed by the director at the time that I was hired that admissions to the bar exam and the licensing was something that he wanted nothing to do with, and he didn't want to grade exams. He didn't want to review transfer petitions. He didn't want to do any of that. So I took the liberty to do the work. I graded all the exams. I reviewed all the transfer petitions. I invited as many people into the legal community as I could. I didn't even know he wanted to have a say in it. And when he told me that he did want to have a say in it, and that was something that he wanted to be informed in, then I started sending him every single admission letter before I sent it to the Supreme Court. So that was a problem that I thought was resolved, because he informed me that he wanted to be involved. So then I started doing that. Oh my god. Oh, we're all dead now. Great. Oh, so is our camera guy. Sorry, way too old. God rest his soul.
Simply BTZ survived. I think it's his alt.
Yeah,
Should I
if
keep
you,
that's the end of my
I'm
answer.
grateful to the Secretary of the Senate for sending the name in the group chat, but I already took care of it. I'm grateful too. Order. Forgive me, colleagues. I'm not sure who. Mr. Simply, the leader did stand in the middle of the statement. I will allow him. Uh, I'll call him first, and I'll come to you next, Mr. Notciolix.
Mr. Chen, which operating system do you use?
The Chief Judge.
Operating system, as in what exactly?
Like on your computer.
Windows 11. Why?
Excuse me.
Objection relevance? Like,
Order. That there's two points that that's no, number one. It's you don't get to ask questions, and number two, I'm not a judge, and the chief judge should stop saying objection because I'm not going to listen to him anymore about that. Simply BTZ. If I will say that the reason I didn't call the leader again is because he didn't stand up again. I assume that means he had nothing further to say. I will simply BTZ. The chief judge.
I have no idea why I was fired. So I don't even know how to answer that question because all of my messages are still unanswered. No conversation or any, you know, I was never put on a pip. I was never told to fix something or stop doing something or start doing something or anything. So, and there's been no communication since. I've messaged him several times throughout the day, and he has not responded to me one time. So I don't even know how to answer that because I don't know why I was fired. So this failure to follow directions thing is the first time I'm hearing of it.
Simply BTZ.
Me too.
Order. Can I say to the honorable gentleman, I was looking for a question mark since he doesn't seem to have one. If there are no further questions, Mr. Chen, you are dismissed.
I thought Walter had another question. No.
He didn't stand up. This is how this works in the Senate.
Oh, okay. Well,
If honorable members have a question, it's incumbent on them to stand up, and he's not. So that's my assumption at that point is that it's not obligatory by any means for him to stand up. He has no further. If he's not standing up, he has nothing further to say. I'll tell the chief judge that he can rely upon me to make sure that that gets taken care of. I thank him for his appearance today. He's dismissed. Thank you. And I will ask him to respawn, please. Or leave the game, either or. You know, I might be looking for a motion to contempt. You know.
I'm dead. You can't kill a dead man in contempt.
That's actually not true.
Please do not make me say preliminary finding. Thank you, Mr. Chen. Have a great day.
You got it.
Order. We remain in legislative business. Simply BTZ. Sorry. I have a keen eye towards the honorable gentleman. The matter at hand remains Resolution 5. The question is the impeachment of the Attorney General. If there are no matters of debate or I will hear points of order if there are any. I'm going to try something new. If there are no further points of order and no further matters of debate, we come now to Bill 3, the Milton University Establishment Act of 2026. Mr. Simply BTZ.
Can he do that? I don't think he can do that. About whether he can do that? can we get an opinion, please?
Fine. The question is the impeachment of the Attorney General. I'm going to sit here in silence until you guys motion. Leader of the Senate.
A point of order. I request the opinion of the parliamentarian on whether it is permissible for the presiding officer to move from one item to the next at the natural conclusion of debate and consideration of that item.
Order. Given that was a point of order, he's going to hear my response first, and he'll resume his seat while I'm giving it. First and foremost, what I would say to the honorable gentleman is he has on numerous occasions shirked his responsibility as the leader of the Senate to produce and publish agendas that would enable me as the presiding officer to move from one agenda item to the next, to the next, to the next. The honorable gentleman is well aware of this requirement of his role. He's been reminded by me of it on countless numerous occasions. He does not need a further reminding of it. Secondly, what I would say to the honorable gentleman is that he has on further numerous occasions advised me that in the instance that he fails to provide an agenda, and indeed it is spelled out within the rules of the Senate that the president is indeed responsible for setting out the order of business in the event of lack of an agenda provided by the leader of the Senate. It is, in the opinion of the chair, entirely proper for me to move down the line of agenda items as per the docket determined by myself. As I said, it was an experimental thing. I'm happy to continue to remain in the present agenda item. I am happy to take the point of the honorable gentleman. I am simply seeking to move forward if there is nothing further on this point. The leader of the Senate.
Thank you, Mr. President. I do actually believe that you should be able to do that. But I seek the opinion of the parliamentarian as to whether you can do that right now, or whether, in fact, we will have to amend that in our the rules amendments, which we are proposing soon at some point, probably.
Using my own authority, I ask the parliamentarian to comment on the matter.
Thank you to the president and the members of the Senate. What I would say is twofold. For one, normally it would not be permitted in regular parliamentary systems, but in our special thing that we got going on here, the way that we've assigned the role of the agenda setting to the leader of the Senate, and how that that ability is usurped by the president when the leader fails to do so, I would say that it is completely within the ability of the president to do so. Especially and it's not like this has any ramifications, because the Senate at any point could motion to return to any business that it prefers. Thank you.
Simply BTZ. Still in legislative business. We never left it. The motion is out of order. Mr. Simply BTZ.
We did go to question period.
I'm grateful to the honorable gentleman and to the leader of the Senate for their repeated and continuing points of order. Let me say clearly and without questioning by honorable members, and I say to the parliamentarian, while I appreciate her opinions, doesn't overturn a ruling of the chair. What I would say to Mr. Simply and to the leader of the Senate is twofold. First of all, I said in response to a point of order by the leader of the Senate at the time that it was raised that the movement to a question period did not fit within the particular structure of business as laid forth by the Senate rules prior to the entrance of a question period. We were indeed, and I'm happy to request that the record be pulled, legislative business. Therefore, at the conclusion of the question period, what would be my interpretation and my understanding as the chair would be that we then return to the business that we formerly left upon the conclusion of such period that we may have entered into by the motion by the honorable gentleman member for Palmer North. What I would say in response to the point of order just raised by the honorable gentleman member for Palmer North is such that the conclusion of the question period enables us to move to further legislative business. That is why I say to the honorable gentleman that he need not motion for us to return to legislative business, because in the opinion of the chair, we're still in legislative business. I hope that that answers the questions of the honorable gentleman. So simply. Is there a second?
Second.
Without objection. The question is the Bill 3, the Milton University Establishment Act of 2026. Simply. Leader of the Senate.
Thank you, Mr. President, and thank you to the member for Palmer North for proposing this legislation. Quick question. Why does Milton University need its own police department?
Simply BTZ. Leader of the Senate.
Thank you, Mr. President. I vehemently oppose the imposition and establishment of another police department. In fact, I think we have too many already. If I had it my way, we would abolish half of the departments which currently exist. I don't think it's necessary. The Milton City Police already doesn't do anything. We don't need another police department to protect and serve the 4 blocks which make up the university campus.
Mr. Simply. Leader of the Senate.
No, I do not think so. I think the Milton City Police does not need more statutory control over the structure of their department. I think the chief is well and able to establish that himself. However, I do think, in fact, that the police should not post dedicated officers on the campus. There's not a permanent population on the campus. In fact, people probably won't be on the campus all that much. More importantly, I think would to provide opportunities for security businesses to be contracted by the university board to provide those services. thereby allowing economic growth as well.
Simply BTZ.
Mr. President,
Leader of the Senate.
I move that the Senate stand adjourned until the next legislative day.
Is there a second? Order. The question is that this House do now adjourn. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Order. The Senate stands adjourned until April 8th, 2026 at the call of the chair. Order.